in progress. हो गया एंट्री। सर क्या करूँ, एंट्री हो गई तो पहले एंट्री हो गई पहले हैं
वन सीपी फ्री वालों हमारा नोटिफिकेशन आई हो
अमित आ गया रहने दे। सर गुड मॉर्निंग सर, गुड आफ्टरनून सर। अमित जी वेलकम।
गुड आफ्टरनून सर, गुड आफ्टरनून।
सुनील चुगी, आपको मेरी आवाज आ रही है? आई वेलकम यू इन द वेबिनार।
हाँ जी, थैंक यू आवाज आ रही है।
सर नमस्कार नमस्कार नमस्कार, कैसे हैं आप?
ठीक हूँ जी।
That's great. Great. Sir, अभी
Good
2-4
morning,
मिनट में
sir.
start करते हैं. Hello. हाँ जी प्रवीण जैन जी नमस्कार कैसे
हाँ
हैं आप?
नमस्कार सर नमस्कार चुप साहब
Welcome to
नमस्कार
Sir, welcome to our seminar webinar.
नमस्कार
Welcome.
जी।
नमस्कार
नमस्कार
सर
जी,
नमस्कार चुप साहब
Mr. Sunil Sethi is there and Mr. Choksi is there. You know, I welcome everybody on their behalf. Mr. Anupam Agarwal is also welcome.
Royalty-free music for videos and media projects. TunePocket.com.
I think now time is 2-3 minutes above. We can start our seminar. Sunil ji, with your kind permission.
For videos and media projects.
Amit ji अपने आप को
Yes.
unmute कर लो.
Yes we can go ahead please
Yeah, we can go ahead. Okay. अमित जी आप अपने आप को unmute कर लीजिए.
यस मेरा आज आ रहा होगा कैन यू हियर मी
Yeah, we can hear you now. Very comfortable. We can hear you now. Okay. This is our in our IPA. This is our the series. We have a second seminar, and earlier last year, last seminar was on the last Saturday. This is my little bit of introduction. Before we start our seminar, let me give you the brief introduction of IPA. IPA was, earliest organization. We formed it in the approximately 4.5 years ago. We have around 70 at its members, and our objective is to take care of IP problems and their development. We are running a lot of WhatsApp, Telegram groups where we give the regular updates, and on mails also. We hold our physical meeting in the March 18, where at that time we invited our at present the concerned minister and the NCAT chairman also. Our future roadmap is to expand horizontally and vertically at national level. Horizontally, I mean to say that we would like to have our branches at all those places where we have NCLT offices, around 20-25 places, number one. Number two, vertically, we would like to go for vertical expansion, like we shall divide our IBC into three parts, and one vertical will be headed by one renowned personality, say CRIP. Another may be the voluntary liquidation. Third one may be the the disciplinary proceedings, and like all these things, we would like to go with the passage of time expansion there. And at the same time, we also want that whosoever IP qualifies, which are around 4,000 right now, he be our member also. सर आज का जो प्रोग्राम है हमने इसको छोटा सा 3 पार्ट्स के अंदर डिवाइड करा है। पहले 15 मिनट मैं लूंगा लेटेस्ट डेवलपमेंट के लिए। उसके बाद 30 मिनट का सर सुनील जी के पास था ये, लेकिन वो बाय चांस कुछ इमरजेंसी हो गई, तो जो हमारे थर्ड स्पीकर हैं मिस्टर अलोक धीर जी, ही भी टेकिंग केयर ऑफ दिस थिंग। उनको कुछ इमरजेंसी आ गई, कुछ फैमिली में डेथ हो गई और उनकी किराए पे जाना था, तो इस करके ही बी प्रोसीडिंग सुनील जी, फॉर विच मिस्टर Sunil has already kindly consulted for that. And after that, we shall have a 15 minutes of panel discussion. जो भी हमारी सेमिनार के अंदर डिस्कशंस इमर्ज होंगी, उनका जवाब हम सब लोग मिलकर देंगे। सर सुनील सर, आलोक देव जी, नीलेश जी, get undisposed of because of some emergency to him also. And नवनीत कुमार जैन जी के घर में भी एक फैमिली के अंदर कल रात को ही all of a sudden death हो गई, तो he may or may not join. But Amit ji ne, our another very senior executive member in our governing body has joined in his place. Okay, our issue is little bit it's quite वो कहते हैं ना, एक गाड़ी के अंदर जैसे अगर हम आईबीसी को एक गाड़ी माने तो उसके अंदर 2 टायर होते हैं जो पैरेलल चलते रहते हैं, उस तरह से गाड़ी चलती रहती है। तो बिफोर आई गो फॉर technical issues on the what IP expect from the COC or what COC expect from the IP, let me little bit go for the brief of what basics are there. Yeah, when our IBC started and we were having the BLRC committee report, BLRC committee report initiates 4 pillars for the implementation of IBC, and among that, number 1 pillar was insolvency professional, number 2 pillar was information utility, and number 3 pillar was judiciary, and number 4 pillar was regulator, which is IBBI. Except these 4 pillars, एक इंफॉर्मेशन यूटिलिटी ने अभी ज्यादा काम करना शुरू नहीं करा. All are doing their job as was expected from them by BLRC. Okay, but with the passage of time, जो हम लोगों को इंसॉल्वेंसी प्रोफेशनल्स को रिस्पॉन्सिबिलिटी दी गई थी, इस रिस्पॉन्सिबिलिटी को प्रैक्टिकली 2 पार्ट्स के अंदर डिवाइड हो गई. एक है जो हमारी रिस्पॉन्सिबिलिटी है इंसॉल्वेंसी प्रोफेशनल्स की, और एक हमारी सुपरविजन के लिए, या एक हमारी पैरेलल पोजीशन के लिए COC. And in fact, I prepared a link also. As per section wise, एक IBBI का बहुत पुराना सर्कुलर था जिसके अंदर उन्होंने बताया था कि इंसॉल्वेंसी प्रोफेशनल की क्या रिस्पॉन्सिबिलिटी है, COC की क्या रिस्पॉन्सिबिलिटी है, either individually or jointly. I just share that circular with you. In fact, this is known to everybody, but still, जब हम लोगों ने COC versus IP versus COC करने की कहा, तो मैंने कहा कि इसको मैं जरा शेयर कर लूं. तो इसके नीचे चार्ट दिया गया है सेक्शन वाइज, सेक्शन और रेगुलेशन वाइज. जो ग्रीन कलर है दैट द रिस्पॉन्सिबिलिटी ऑफ IRP. जो रेड है, जैसे इस चार्ट के अंदर अब आ गया, ये हमारी रिस्पॉन्सिबिलिटी नहीं है. फॉर एग्जांपल, लेट्स मेकिंग पब्लिक अनाउंसमेंट विद इन 3 days, इट्स एब्सोल्युटली रिस्पॉन्सिबिलिटी ऑफ द IRP. Confirmation of IRP as RP as replacement with another IP as RP under section 22 subsection 2. This has to be definitely done by the COC. इनफैक्ट जब शुरू में हमने इंसॉल्वेंसी की प्रैक्टिस स्टार्ट करी थी, तो दिस चार्ट वाज रियली हेल्पिंग मी इन माय होल्डिंग COC मिनट्स. तो most of you be aware of it, but if still you are not aware of it, you can refer this circular along with chart and can harmonization in all the COC minutes. Like in this case, responsibility lies with both CD and with IP also under section 28 subsection 1 subsection E with reference to payment limit from bank accounts undertaken any related party transaction. Responsibility lies with both of us, and for passing of this 2/3 of the voting share is required. This was all brief. I thought of sharing it briefly because so that let we be abreast of the basics. In my, either as a process advisor or as IRP, RP, or liquidator, I handled around 25 assignments. In most of my assignments, and in fact, most of this thing happened with the IPs also, and with every COC member also. We work hand in hand together. Objective is जो हमारा एक IBC का objective है value maximization के लिए. But what is happening, जैसे एक फैमिली मेंबर क्या होता है ना, जब बच्चे छोटे होते हैं तो माँ बाप भी बच्चों को बहुत प्यार करते हैं और बच्चे जो मर्जी कर लें वो उनको प्यार करते रहते हैं. लेकिन जैसे जैसे ही पीपल स्टार्टेड ग्रोइंग, एक दूसरे से एक्सपेक्टेशन बढ़ जाती हैं. जब एक्सपेक्टेशन बढ़ जाती हैं तो जहां पे एक्सपेक्टेशन बढ़ती हैं वहां पे मेनी टाइम्स और समटाइम्स थोड़ा बहुत कंफ्लिक्ट आ जाता है. बट दैट इज ऑल रिजॉल्वेबल. When running an IBC show is like running a family. और जैसे हम लोग एक्सपर्ट अपनी फैमिली रन करने के लिए the way we are running IBC together. Now, first of all, let me say, address you. What are the COC expectations from IP? जो सबसे बड़ी हमारी फाइनेंशियल कैडर COC की कमेटी ऑफ कैडर्स की एक्सपेक्ट्स होती है वो यही होती है कि हम रिकवरी जिसके लिए उन्होंने हमारे को अपॉइंट करा है, वी शुड हैव मैक्सिमम रिकवरी फ्रॉम कॉर्पोरेट डेटर CD. Since we have a lot of bankers with also, especially Sunil sir, जो बहुत senior है और इनको तो he is pioneer in NCLT work and everything. He has got very very good experience. और अभी इनका डिटेल में बायोडाटा मैं थोड़ी देर में इनके बारे में आपको बताऊंगा. तो then everybody will be amazed कि इतना ज्यादा इनको एक्सपीरियंस और इतने ज्यादा इन लोगों ने, यानी कि सर ने इतने ज्यादा वो असाइनमेंट्स हैंडल करी हैं. तो इसमें हमारा व्हाट हैपन, जो IBC के लिए जो भी कॉर्पोरेट डेटर आता है, we have one not complaint but a sort of saying to them that they bring C to us when he is on ventilator. And see, when एक आदमी जो the ventilator पे है, जो एक बिल्कुल lost stage पे है, जब उसके पास कोई रिजोर्ट नहीं होता, then getting maximum recovery from them is little bit difficult. On the other hand, if any alive company is brought to us, whereby we be asked to bring a solution for the IBC, so most probably we'll be able to give far better results. Second point is that no doubt a good asset base is created out of the loans provided by you, but with the effects of time, all that get eroded, and the only remains are negative capital plus bank loan with no assets. अब इसका solution क्या है? We are here not to raise the issues only. We are here to for the solutions for that also. Please bring CD to us when she is young. I mean, it has a good asset base created out of your funds. As a young bride can always command a good bridegroom, we can also bring a very good RA for you. I agree. Sometimes destiny also plays a very on role. But as of late, what is happening? Recently, PF authorities have started knocking to us. They say that the amount payable to the financial creditors से पहले हमारी जो अगर dues है उनको आप पे करो. So what I mean to say is that कि Section 11 के अंदर उनके पास it has a priority over even unsecured debtors secured debtors payment. तो what I mean to say is that कि जैसे जैसे पैसेज होता रहता है, जैसे जैसे टाइम बीता रहता है, उनके हिंजेस हैं वो बढ़ते रहते हैं और एसेट्स जो हैं वो डिल्यूट होते रहते हैं. इस करके whenever you feel that it's my humble submission to bankers, whenever they feel that this particular industry or this corporate debtor is ailing, so try to bring that particular corporate debtor to us when he is not on ventilator. Second problem what we face, most of the time promoters directors are real culprits known to all. और ये कहते हैं ना, जज को पता होता है कि ये कौन सा बंदा चोर है और कौन सा कैसा है, but he is only looking after evidences. Similarly with us also, the reason of not able to give you better recovery is that most of the time directors promoters are are culprit. RP detects all these as per transaction under section 43, 45, 66, 55. But practically no recovery is being made. यार जितने भी आज के डेट में NCLT के जो एनक्लेड के ऑर्डर्स आए हैं उनके अंदर मैंने नहीं देखा किसी के अंदर भी किसी प्रमोटर को पेनलाइज किया गया है या उनसे रिकवरी अच्छी हो पाई है. तो इसके लिए डिस्पाइट डूइंग ऑल द बेस्ट एफर्ट्स बाय आरपी वी आर हैंडीकैप्ड एंड नॉट एबल टू रिकवर जो हमारे को पता भी है कि इस तरह से मनी को निकाला गया है बिजनेस से. फॉर दैट यू हैव टू बेयर विद अस. दिस इज आवर लिमिटेशन. What we feel is that इसका जो हम लोगों ने यानी कि हमारे इसके अंदर डिस्कशन भी हुआ था many a times with our promoters and many times in our fraternity also and with bankers also. जब तक जुडिशरी इनको कोई वार्निंग साइन नहीं देती कि यानी बेसिकली जब तक दो ही ऑप्शन है कि ये पता चल गया कि इस प्रमोटर ने पैसे निकाले हैं और डिफ्लेट करे हैं, या तो वो पैसे वापस करे, अगर वो पैसे नहीं वापस करेगा तो देन ही हैज टू गो बिहाइंड बार. टिल देन पैसा तो बैंकर्स ने या फाइनेंशियल क्रेडिटर्स ने दिया, कहीं ना कहीं तो वो किसी ना किसी फॉर्म में पड़ा हुआ है और बस उस फॉर्म को वापस आप बैंकर्स को देना या सीओसी को देना, दैट इज आवर डिजायर एंड ड्यूटी आल्सो. एंड वो कैसे हो सकता है? फॉर दैट जुडिशरी नीड टू बी लिटिल बिट स्ट्रिक्ट द वे आईबीबीआई स्ट्रिक्ट ऑन वीआईपीज. हम कोई भी प्रोसीजर फॉल्ट करें, कुछ भी करें, IBB is always teaches us a lesson. Similarly, we expect that if money need to be recovered, money is parked with the there are some many a times the business losses also, but many a times promoters also take out the money from the business. Yeah. एक छोटी सी और रिक्वेस्ट है हमारा बैंकर्स के साथ कि जैसे हमारे यहाँ पे इट्स प्रूडेंसी इनफैक्ट डिमांड दिस थिंग दैट एन L1 system of selection is there. Fees quotations are going 20,000-30,000 rupees against earlier 1.5 lakh rupees for 6 months. Please have a relook on this system because अगर आप इस lower level तक फीस जाते रही तो the time is not far off. When you will you never get an experienced RP, you will never get a person जो ऑलरेडी अच्छे तरह काम कर रहा है, जिसके पास अच्छे प्राइवेट काम है. तो but now I'm very happy that only 2 days ago 9 तारीख को ही ये IBB has come out with a gazette notification where they have specified a fee structure in 2-3 parts, जो भी हम बाद में थोड़ी देर में डिस्कस करेंगे. So maybe that we taken, it has been divided in 2 parts. One is compulsory and another is discretionary. So let's see that this is being used by the bankers. Another, problem with us is that in 30% of the cases, scrip expenses and fees are not paid to IRP, RP by the applicant COC. Your argument is, whenever we have this sort of argument with the COC के भैया, अब जो एक मैंडेटरी खर्चे हैं उनकी तो आप रीइंबर्स कर दीजिए, जो हमारी एक मिनिमम फीस बनती है, हम लोग काम कर रहे हैं वो तो कर दीजिए. तो आर्गुमेंट इज ऑलवेज दैट it's a not argument but it's a as a matter of prudency on the part of bankers, why should we spend good money after bad money, because we know that this is going to be the more losses. But sir, my only humble submission is that we are running a correct process. अगर किसी बंदे को जेल में भी डाला जाता है तो उसको भी एक बेसिक चीजें दी जाती है फूड और सैनिटेशन की. Similarly, we expect and we request that for running this process, जो भी एक रीजनेबल फीस है या जो भी एक क्रिप के एक्सपेंसेस है वो हमारे को उसके लिए पोस्ट टू पिलर तक ना जाना पड़े. दैट शुड बी रीइंबर्स्ड टू अस एज प्रॉम्प्टली एज पॉसिबल. Another problem I faced when I was doing these CRIP assignments and other things is that एक हमारी COC मीटिंग में तो जो होता है सो होता है. I found many a times that many of the COC members try to negotiate with us on back door. What negotiation they do? अगर हम लोग यानी कि प्रमोटर्स को किसी तरह से इम्प्रेस करके OTS का अमाउंट एक पर्टिकुलर लेवल पे लेके आते हैं COC मीटिंग में, जैसे ही COC मीटिंग खत्म होगी they will come with with us, नहीं इसको मनोज जी थोड़ा सा और बढ़ाओ, ये इसको थोड़ा सा और करो. Claim verification अंदर we find many a time lot of lobbying is done to us कि claim with interest, without interest, with penalty, with charges as per sanction and this thing, they are also being forced to us. तीसरी चीज मैंने ये देखी है कि जैसे वैल्यू और फॉरेस्टिंग के डिटेल्स हम अपॉइंट करते हैं, many a time we are not in COC meeting, many a time we are being pressurized that they should be appointed out of their panel. And if we don't bend upon from their suggestions or this thing, then they have their internal reporting system. Then they go for negative reporting as a result of which you don't get assignments in the coming days. There may be exceptional cases, maybe from the bankers or from the bankers perspective, जब भी वो नया पैनल बनाए उसके अंदर हो सकता है 0.1% ही वो IPs को वो दोबारा पैनल नहीं करते हो. बट सर ट्राई टू अंडरस्टैंड दिस थिंग. बैंकर के लिए 0.1 हो सकता है, लेकिन दैट पर्टिकुलर IP के लिए इट इज 100%. Meaning thereby, have a pragmatic view on our decisions also. At last, I shall say that despite all this around, we have 19,000 cases settled under second trial way, and India's ease of doing business ranking also improved, with the collective efforts of everybody from 139 to 63. At the same time, I think Mr. Alok Dheer has joined. Alok Dheer ji, I welcome you there. If the judiciary starts giving pronouncements treating timelines as mandatory rather than direct in nature, most of COC expectations shall be met, and all sections 7, 9, 10, 54C, 59, 94, 95 applications are, what from the judiciary we expect, at least जो उनके लिए timeline है, जो स्विस रिबन के केस में कहा गया कि IBC ने जो भी timeline उनके लिए दी हैं, those are all directory in nature, and for us everything is bundled way. पहला तो ये एक बहुत बड़ा डिस्क्रिमिनेशन है. चलिए, अगेन लेट्स ओवरराइड दैट डिस्क्रिमिनेशन. आई रिक्वेस्ट कि एटलीस्ट जो एडमिशन के लिए है, बिकॉज नाउ वी आर सीइंग एडमिशन के लिए साल, 1.5 साल, 2 साल, 2.5 साल तक का टाइम लग जाता है. तो यू कैन अंडरस्टैंड कि जब एक प्रमोटर को इतना टाइम मिल जाएगा तो वो प्रमोटर कैसे उस CD को छोड़ेगा फॉर एनी रेजिस्ट्रेशन पर्पस और फॉर एनीथिंग एल्स. So we expect and request that this is the request from the behalf of IPs and COC also. At least admission जो है वो जो भी इसके अंदर है कि within 30 days they should take a call, and judiciary should take a call and either accept it or reject the application. Yeah, when we were, there is an IBS circle which I would like to share with you. I just reached to the last point. This IBBS circular instructs us that in view of the IRP or RP, as the case may be, is directed that he shall, in every notice of the meeting of the COC and any other communication addressed to the financial creditor other than 21(6)(a), require that they must be represented in the COC or in any meeting of the COC by such persons who are competent and all authorized to take decision on the spot and without the different decision for want of any internal approvals from the financial sources. ये मैं अपनी हर नोटिस के अंदर लिखता हूँ, बट प्रैक्टिकली इसका कोई इम्प्लीमेंटेशन नहीं हो पाता. तो दिस इज आल्सो वन ऑफ आवर एक्सपेक्टेशन फ्रॉम द COC कि एटलीस्ट हमारी बात तो आप सुनते ही हैं, लेकिन जो एक मैंडेटरी लीगल बात है IBBI ने विद एक्सपीरियंस कह रखा है, तो प्लीज जरा उसको भी आप थोड़ा सा ध्यान दीजिए. ओके, ये ऑलरेडी 3:22 हो गए हैं, तो लोग जी को थोड़ी सी जल्दी है, तो आई जस्ट स्टॉप माय प्रेजेंटेशन व्हिच आई शैल टेक नाउ. ओनली थिंग्स आर लेफ्ट विद मी इज दैट इश्यूज एंड सॉल्यूशंस फॉर IPs, तो वो हम लोग बाद में ले लेंगे. लेट आई रिक्वेस्ट माय नाउ आई जस्ट स्टॉप माय शेयरिंग नाउ. सर आलोक सर, आप हैं सर? आर यू एबल टू हियर मी नाउ? लोकदीप जी, आप प्लीज अपने आप को अनम्यूट कर लीजिए। एक्चुअली लोकदीप सर जी ने मेरे को रिक्वेस्ट करी थी कि आप 3:30 के पहले का उस आसपास मेरा प्रेजेंटेशन शुरू करवा देना। दैट इज आई एम रिक्वेस्टिंग लोकदीप जी, बट आई थिंक ही इज नॉट देयर। चलिए, इन द मीन टाइम सुनील सर, जब तक लोकदीप जी आते हैं, प्लीज हैव योर सम सेइंग ऑन दिस थिंग देयर। सर अनम्यूट कर लीजिए अपने आप को प्लीज।
Yes, yes, yes. So,
Thank
very
you.
good afternoon to the audience here. It's nice opportunity for me to be part of this deliberation today, and I also came in this webinar with the curiosity of getting some inputs and insights into what is going on there in the minds of various insolvency professionals. And I was very keen to know about the expectations of insolvency professionals from COC members. Uh, while the formal speaker on this topic is yet to, I think, join or yet to start his deliberation, and I have heard a long list of expectations already from Anandji. So before I respond to all these expectations or whatever issues and solutions or suggestions that you have given, I will definitely touch upon them towards the end of my discussion. Before that, I would like to start a discussion on the mandate that has been given to me for this webinar, that is COC's expectations from the insolvency professionals. So let me dwell upon that topic for next few minutes, and then I'll
Yes
come
sir,
back.
yes sir.
So thank you very much, Anandji, for giving me this opportunity. As already narrated by you in your presentation, that IBC envisaged 4 pillars of this entire process, and the very first pillar is insolvency professional, and other 3 pillars, as narrated by you, information utility or adjudicating authority or the regulator, that is IBBI. All three pillars are basically institutions. Information utility is more of a data provider and a data maintaining agency. Adjudicating authority is a judiciary which has a very limited scope to examine the resolution plans for approval within the mandate of the law given in the particular section, whether the resolution plan complies with that and the process has been followed accordingly. And there is a very limited scope. And as far as our regulator is concerned, they have to take care of the overall development of the and regulate the profession, regulate the entire process, bring out laws, regulations for that. So it is the resolution professional or the insolvency professional who is an individual and who is at the front end of the entire process. All others are basically facilitators. It is the insolvency professional who, with the help of COC, has to be there on the ground, do everything, start the process, take it to the logical end, uh, ensure that the entire process is run as per the norms, as per the laws. A lot of expectations are there on the insolvency professionals. Of course, it's again, as already spoken by Anandji, that both sides have expectations from each other, and then there always remain sometimes gaps in fulfilling those expectations. But I would really commend and appreciate the role that the insolvency professionals are playing and the huge responsibility that they are shouldering in the entire IBC ecosystem. And I compliment their role in the entire process. Now, there are several responsibilities or duties that are cast on the shoulders of the insolvency professional as per the code also. Anandji, should I continue or you want Alok Dhirji to first spell out his
Sir,
expectations?
actually, he just called me up. He says that within 1 or 2 minutes, he be
He has
joining.
joined.
You know,
I saw
I'm already
he
here.
has already joined.
okay. Great, sir. Great. सर मैं 2 मिनट लूंगा. इनफैक्ट इट इज एक ट्रेडिशनली हम लोगों को ऐसे करना होता है, बट somehow with overlapping we were able to just miss it out. मैं सुनील चुग जी का थोड़ा सा इंट्रोडक्शन देना चाहूंगा. He is a chartered accountant. He is at present GM with the PNB and has been in the banking since 1993. And he has a very vast experience. He has an experience of working for 5 banks. And as far as IBC is concerned, so 2016 से जब से IBC आया तब से he is working there. And as far as I know him, he was earlier in OBC. So I used to meet him there at HO OBC also. He has been pioneer in most of the COC meetings. He has attended most of the all big accounts of PNB and headed the NCLT cell at PNB also since last 2 years. But recently he has been moved to some other maybe some better place. So we are really blessed, sir. आप इतने experienced banker हमारे साथ आए हैं, हमारे को अपना experience share करेंगे, and in that process we should learn also.
No, should I continue or you want Alok Dheer ji to first give, because you
Sir,
said you
Alok
would-
Dheer sir, आप बताइए कैसे करें? Would you like to start?
Sir, Chuk Sahab, firstly, of course, you are such a well-known person in the entire industry. So, introduction was not really required. आपको तो सभी जानते हैं. Be that as it.
Introduction हम आपकी भी देंगे थोड़ी सी. आप भी बहुत renowned हो.
So, unfortunately, what has happened, Sunilji, and that's why I must seek this indulgence from you. My maternal uncle died, and I have to go there. So
no issue.
I did not
Start your
want to.
discussion. I can definitely wait. No issue.
So that is why I had requested Manoj ji कि मुझे accommodate कर दीजिए. I didn't want to lose the opportunity of being with all our IP colleagues and obviously hearing you as well. But I just sought that indulgence so that I can just spend 15 minutes. I didn't want to simply cancel my,
Yeah, you can go
involvement
ahead.
with this meeting today.
Sir, may I take the liberty of, although you don't require any introduction, but still, as a matter of tradition and practice, I just give you the introduction of Mr. Lokdeen. He's also a qualified chartered accountant and a renowned lawyer in restructuring and is in the law practice since 1983. As far as I know him from National Textile Corporation, one of the biggest restructuring account in India. Since last 20 years. And he is a specialist in corporate and financial restructuring, insolvency laws, merger and acquisition, banking law, and real estate. He is a managing partner of Dheer & Dheer Associate, which is rated as one of the top insolvency firm in India. He has a presence not only in India but internationally also. He is the co-chairman of many associations, including SOCOM, and he is in a lot of committees of Government of India, of IBBI, ICSI, and many similar committees also. We are really blessed with your, your deliberation, sir. अपने लिए 2-4-5 मिनट last में spare रखना. We have some volley of questions for you also. Please start your deliberation, Alok sir.
Thank you, Manoj. I think it is very kind of you to say what you did. We are all humble practitioners and we are all colleagues in that sense, and we learn from each other every day. It's just that this is an opportunity. And I must tell you, every time one speaks, there is an opportunity to try to reflect upon things, and you end up gaining more from having come forward than anybody else who's listening. But let me start by thanking AIIPA and Manoj, the president, to invite me for speaking on the expectations of the IPs from the COC. So Mr. Sunil Chugh has just spoken on the expectations of the COC from the IP. Both are very interesting topics, as the relationship between the COC and the IP is in the center stage of the entire IBC, particularly the CI. That's the crucial linchpin for the entire process. When I read the topics for the day, I just reflected a bit as to what is the expectation from each other in a relationship. I mean, on a larger scale rather than just IP and COC. Both COC and RP are two crucial pillars of the resolution process to achieve the effective resolution of a corporate person in a time-bound manner. They are bound together in an exceedingly complex but symbiotic relationship by the provisions of IBC, rules and regulations framed thereunder, and if I may say now, the code of conduct which is there already for the RP and will likely to be there for the COC. So they have to act in tandem with each other to achieve the desired objective. One cannot perform its role without the support of the other. The code envisages the COC to be the primary decision maker and the supreme decision making body, and RP as the master of ceremonies to conduct the process and create an environment within which the COC can take effective and pragmatic decisions to resolve the corporate debtor for the benefit of the stakeholders and contribute to the economy of the country. So that is the mutual role between these two. So for this Jugalbandi to succeed, the RP has to act in the best interest of the creditors as a whole, in good faith, fairly, honorably, independently, impartially, within the four corners of law. And equally, the COC has to support the entire process and the RP by taking timely and fair decisions in the larger interest of value maximization and balancing the interest of all the stakeholders. The expectations of the RP from the COC and vice versa arise out of mutual respect, rights, duties, responsibilities, and obligations towards each other, and the powers given to them respectively under the provisions of the IBC to achieve the common objectives under the Act. It's like both of them are running a three-legged race. They are tied together from hand to foot. They have to synchronize and calibrate each step in the larger interest of achieving the objectives of the IBC. One wrong step by either party can land the whole process in trouble. The RP is also like a sutradhar in this process. He is the director and the master of ceremonies, but the ultimate beneficiary, the decision maker, are the financial creditors who compromise the COC and the other stakeholders. On a lighter side, when I was looking at the relationship and expectations from each other, I just thought in my mind that this relationship can also be compared to a marriage. The husband is the RP. He has to do all the work. All the hard work has to be done by him. He has to run the process. He has to do everything. He has to keep the process within the four corners of law, convene meetings. So there's a lot of work that he has to do. But whatever he ultimately generates, when the resolution happens, everything goes to the wife, to the COC and the financial creditors. He can give his suggestions, but ultimately, as we all know, he has to do what his wife tells him. So in that way, the RP status is this, that he is responsible for doing and running the entire process, but he is under the ultimate command of the COC. Also, again, another analogy of the relationship I'll give is the relationship is like between a Pandit and his Jajman. The Pandit is the RP. He is appointed by the Jajman, the COC. He is technically qualified. He knows all the mantras. As in the case of RP, he has to know all the laws. And conducts the entire ceremony, which is the other. But what are the blessings of God ultimately go to the Jajman, which is the COC. They are the ones who are the principal stakeholders who benefit from this. So the IP does not benefit from the process in any way, except for the purpose of getting his fee for doing the entire exercise. So the entire process starts with the filing of the petition under section 7, 9 or 10. RP is recommended by the applicant in the respective case, and on the admission of the petition, the adjudicating authority appoints. The RP collates all the claims, forms the comprising of the financial creditors, except of course the related parties. He has to convene a COC meeting within 7 days of constituting the COC, and from that date, the Jugalbandi between the RP and the COC starts. The RP, and just to see what are the respective powers the RP has been given the power to manage the affairs of the CD, and the management of the CD vests with him in terms of section 17 and also 23(2) between IRP and RP. Section 18 lays down the duties of the RP. What are the duties that he has to perform? The COC, on the other hand, is constituted under section 21 and has the right to take all decisions in the IRP process with voting rights of majority of 51%, except for very crucial right, and that is the replacement of the RP in terms of section 22(2) and 27, approval of resolution plan under section 34, and all actions to be taken by RP under section 28(1) with 66% majority. Just give me a second. Beta suno. The right of the COC to replace the RP is a very crucial right and defines it as an ultimately superior authority in the relationship between the two of them. This right has led to certain pressures on the RP. There are cases which we have come across where the RP has been, I'm not taking, it's not a question of the legal issues in this matter today. The issues where the RP has been pressurized to pay the dues of even the financial creditors and their lawyers. There are cases where the RP has been pressurized to pay the amounts to the financial creditors from out of the funds of the corporate debtor. All these have been brought into the ambit because there is that special right that the COC has of replacing the RP. Now, what we have to understand as we go along in the CIRP and the development of this law in the country, that when the code of conduct of the COC kicks in, we have to see and ensure that the COC exercises this right in a very reasonable and fair manner. As things stand today, as we are all aware, even the Supreme Court has held that there is no requirement for the COC to give any reason whatsoever for replacement of the RP. In case there is no such obligation on the COC to give any reason for replacing the RP, the position of the RP becomes vulnerable and he is always obligated to the COC for his very existence, which may ultimately lead to certain practices which may not be desirable and in the long-term interest of the CIRP process. And insofar as the code of conduct which is being promulgated with respect to the COC, there are certain issues in that code of conduct which are very important and we need to look at them. One of them is that the COC is required to cooperate with the RP. Very, very crucial, because without the mutual cooperation between each other, this will not work. Then, not to influence the decision of the committee or the RP. So, keeping that strong position that the COC has with respect as against that of an RP, the influencing of the decision by the COC of the RP should not happen, because this will disturb the balance of the IBC altogether. Also the COC has the responsibility, and therefore RP has an expectation that will facilitate the appointment of professionals within specified timelines. Within specified timelines. They have to cooperate with the RP for giving various approvals which are required to be given from time to time, including extension of timelines, because without the approval of the COC, even the RP is not entitled to proceed to seek extension of timelines for conduct of the COC. In provision of interim finance is also a very crucial expectation that the RP has. Many times we have seen that the COCs don't have cash flow generation. They don't have money to pay the RP. They don't have funds for the purpose of security of the corporate debtor. They don't have funds for the payment of professionals. They don't have funds for even the newspaper advertisements which are required to be given. So the expectation of the RP and the responsibility of the COC as per the code of conduct would be that they have to make sure that funds are available. Either they should be brought in as interim funds and they should give approvals. We have seen in many cases that the COCs are differing. Some interim finance NBFCs who are willing to give money are asking for their pound of flesh. They are asking for high interest rates, undoubtedly. But if there is no money to conduct the process, what will the RP do? The COC has to act. Either the COC should see as financial creditors, they should provide the money, or they should allow the RP to get the money. Then they have to also ensure that they are taking the measures to see that the cost of the CIRP are reasonable. In many cases, it has been seen that highly exaggerated costs get booked for the CIRP, and that creates a difficulty at the stage when the resolution plan is to be approved and distribution has to be done. Then the expectations of the RP are that all the COC members will attend the meetings. We are seeing sometimes even quorum is not there. The COC members are not even coming for the meeting. In one of the cases, the NCLT owned logistics, if I'm not mistaken, has put a fine of 1 lakh rupees on the COC member for not attending a single meeting during the entire CIRP process. Then they have to ensure that tactics of delay tactics are not there in decision making with respect to resolution plans. So we have seen the resolution plan is to be placed before the COC. They take such a long time in discussing the plan because they are not authorized. The people who are attending, the COC members who are attending the meetings are not authorized by their respective banks for the purpose of decision making. So it is a legitimate expectation of the resolution professional that they will appoint such persons who are entitled to take decisions. I must say, I'm so sorry, Manojji. I must say I could have gone on and explained this further, but it's extremely difficult for me because I have to attend a crucial personal function and I must leave now to be there in time. It's just that I wanted to be here with you all and I did not want to last minute say that I'm unable to come today. So you must excuse me today, sir.
Yeah,
And
thank you
Mr.
very
Chuk,
much.
I must
Thank you.
apologize to you again for having interrupted you for 15-20 minutes. And it's not fair of me, but unfortunately the situation so demanded.
Raishu, we are with you. You can go ahead and attend your personal exigencies.
Can I stop you for 2-3 minutes if comfortable?
Manojji, I'm already, my family
Okay,
is
okay.
waiting in the car downstairs and I can see that they are sending messages that please
Yes,
come.
yes.
I'm,
Okay.
Thank you so much, everybody. Apologize again for leaving midway.
No, please. We are blessed with your teaching, and we shall use your time sometime else in the coming days.
Thank you, sir. Thank you.
Sir, Sunil sir, please carry on.
Yes, sure. So it's good that now I have the expectations of RPs from COC available with me from both the speakers, including the Alok Dhirji and Anandji also narrated on the same lines in the beginning. So I will go ahead with what I feel are the expectations of COC from the insolvency professionals, and then I will definitely respond to the other issues which have been raised here. So it won't be an exaggeration if I say that the successful resolution of a corporate debtor depends largely on the shoulders of the insolvency professional amongst all the stakeholders which are involved in this entire process, because he has to manage the entire show, entire process, right from taking over the possession of the corporate debtor when the corporate debtor gets admitted, to reaching the logical conclusion and handing over the CD to the successful resolution applicant, this is a long journey which he has to entirely travel and face all the difficulties in the entire journey. And definitely the other players, whether it is adjudicating authority or COC or the regulator or anybody else, are all passive players, I would say. They are in a supportive role. So the biggest expectation from a resolution professional by COC is, of course, the successful resolution of the corporate debtor and the maximization of value. So this is the broad framework. There would be some steps for achieving this end. This goal is narrated in the code itself, that the value maximization and balancing the interest of all the stakeholders has to be there. This responsibility primarily lies with the RP, and COC has to facilitate through their voting and through their decisions. So the very first thing that RP has to do is to take control of the assets of the corporate debtor, which we find sometimes that there are delays. The promoters may delay handing over the possession amicably, or may not hand over the books of account, or may create some other hurdles, and the RP has to cross this challenge. And there is a provision in law that they can make an application with the adjudicating authority under section 19. So RP is supposed to take timely steps to take control of the asset so that the resolution process can start timely. We have experienced in a very few cases rather that in the entire tenor of 180 or 270 days, RP could not take full control of the CD. But there has been very rare instances of such kind. Nevertheless, such instances existed. So RP is expected to be very tough in these situations and ensure that he abides by the mandate given by the law. After taking the possession, the next responsibility is to ensure that the value is preserved, be it ensuring adequate insurance of assets, or ensuring that the CD remains a going concern so that the value is preserved till resolution happens. And for ensuring that the CD remains a going concern, RP has to make assure that all the critical employees remain there with the company. All the relationships with the buyers, the suppliers, and other stakeholders which are helpful in running the CD as a going concern, those relations are preserved. It is possible that when the CD went into difficulty, those relationships became sour. Maybe suppliers also would have become operational creditors and filed claims, and they may not cooperate, but their cooperation would be essential to continue the supplies. So this balancing act has to be done by the resolution professional, and that is the expectation not only of COC, in fact, all the stakeholders, that the CD will continue as a going concern, and the value not only would be preserved, but also there would be value accretion generated by RP while running the corporate debtor during the CRP process. We have seen very successful cases where the corporate debtor was incurring losses when it was being run by the promoters. But when RP took control during the CRP process, he could run it profitably and generate EBITDA. So there are success stories also, and some RPs have done very good job. Of course, it becomes very difficult when the CD lands up in the CRP process after a delay, and when it has already either it is not functioning or it is heading towards a kind of closure of the unit. It is a closure of the unit. In those cases, it becomes very challenging for the insolvency professional to restart the operations, because there will be requirement of reviving the supply chains, buyer relationships, interim funding, and all that. Nevertheless, it is expected by COC that RP will do his best to preserve and add the value to the assets of the CD. Adherence to the timelines is another important thing that is expected. There are model timelines given in the regulations, and we find that many times there are delays, sometimes beyond the control of RP, sometimes would be within the control of RP as well. It is expected that RP would run the process very efficiently and try to complete it within the given schedule. Not only try to complete it within the given schedule, but also spare adequate time for the COC members to take decisions on the resolution plans. We find many times situation arises when the resolution plan is put to voting when only a very few days, maybe 1 or 2 days or 10 days are left out in the CRP process, and COC is under a compulsion to vote on a resolution plan without fully applying a mind to it. And you would agree that most of the COC members are banks, maybe public sector or private sector banks, and all these COCs members have a system in place for obtaining the approvals of their internal committees. In these banks, powers are not delegated to individuals. There are CVC guidelines, there are Ministry of Finance guidelines, which say that the powers for taking crucial decisions which involve either sanction of credit facilities or taking huge haircut in the resolution or recovery cases cannot be delegated to individuals, and they are delegated to committees. And committees also have limited powers at lower level, and then the powers for larger haircuts are at the senior level, fairly senior level. Sometimes even board level committees are there, and the committees happen maybe once in a fortnight, once in a week, or once in a month. And in those cases, it's become really challenging for the COC members to bring approvals for the resolution plans in a short time frame. So there are compulsions on both sides, and we need to understand each other's compulsions, I believe. So next expectations from the resolution professional is that he will run the entire CRP process with the highest standards of integrity. He will have highest standards of ethical practices. He will act as per as a prudent person would act. He will try to ensure that the process is run in the spirit that is required. And above all, it is very essential that the confidentiality of the information is maintained throughout the process, and no information is leaked out at any stage in the entire CRP process before actually it is supposed to be divulged as per the law. And RP has to ensure that his team members as well must maintain the confidentiality of the information. Not only team members, in fact, the other stakeholders who have access to the information, could be a valuer, could be a transaction auditor appointed by, or any other professional appointed by RP for his support in the process. Those people also maintain the confidentiality of the information and reveal the information only when it is actually as per law permitted to be revealed. Confidentiality of information is a big issue. In fact, we have seen that while it will be difficult to prove it, but then we have seen many instances practically where the resolution plans are found to be very, very close to liquidation value. And this has become more of a norm in the recent past, that resolution plan is very close to the liquidation value, maybe 5% plus minus. And those cases, in fact, raise questions as to whether the confidentiality of liquidation value was maintained, or in one of the cases, in fact, Honorable Adjudicating Authority also commented, and it was a very big news item also, and so many days it was debated upon in the media, that how could the resolution plan be so close to the liquidation value. So confidentiality is very important in the entire process, because the responsibilities and the duties of RP are laid down by the law. It is his duty, and in fact necessary for him to keep himself updated about the latest amendments, latest guidelines, latest jurisprudence, any latest judgments coming which affect his role. RP has to continuously keep himself updated and keep on studying, in fact, studying a lot. Even on COC side, when I was performing this role until last week, I also had to keep on reading a lot. So many Supreme Court or NCLAT judgments will come which would be very, very relevant for you to keep yourself updated. So you have to be on the toes as far as your updation of knowledge is concerned. Even with regard to the industry that RP is handling a particular CRP process in a particular industry, he should be aware of what is happening in that industry and what is the likelihood of successful resolution, on what could be the reasonable value he can fetch for a particular unit. So he has to keep an eye on what is happening in the industry, whether it is a growing industry or it is already in doldrums. So those kind of informations are very helpful in taking the process forward. Another responsibility of the RP is to engage with professionals, that is valuers, transaction auditors, legal people, and maybe other support agencies in the entire CRP process. So here it is very important that the RP chooses, because it is the authority of the RP to select those individuals. Probably the fees might be with the approval of COC, but COC doesn't have much say in the selection of particular individuals. I can't comment on rare occasional instances where probably some of the COC members would have wanted some RPs, as narrated by the speakers, that a particular individual on their panel to be chosen or all that. Those are probably more of exceptional instances that would happen in anything. But usually COC would be a scattered body of several institutions in larger cases mostly. And then choice of one person may not prevail in the COC. In fact, COC would have scattered voting power. So any individual institution cannot prevail upon the entire COC. And those kind of things we have seen practically happening when even amongst the COC members, there are differences of opinion. And then those differences have to be sorted out. So it's difficult to imagine, unless there is a sole banking scenario, that any COC member would have extra influence on the RP. Nevertheless, rare instances cannot be ruled out where such attempts can be made for some individuals. So engaging those professionals is a very important thing, because a large responsibility also lies on the shoulders of the valuers who give the valuation. And this has become a very, very contentious issue. In fact, that we have seen that the valuations become a very, very big issue of difference of opinion amongst COC members and RP sometimes, because the value that financial creditors are holding on their records are sometimes, or in fact many times, of much higher value than what is yielded during the CRP process. It's not surprising to see that the value which comes during the CRP process is sometimes lower than even 40 to 50% of the value which is available on FC's records, and the FC's record valuation is also not more than a year old. Or sometimes we take the latest valuation also. Those valuations are also substantially higher than what the valuation has been parallelly taken by or within a short time frame taken by RP from his appointed valuer. So these kind of issues crop up, and then they really create very difficult situation, not only for the RP but also for the COC members when they go back to their committees for taking an approval on a resolution plan. Definitely, committee members ask very tough questions to the people below who have to present the resolution plan, that how could the value deteriorate so fast, and so much of deterioration in value could happen. How have you ensured that the value is fair and reasonable? So, and it becomes very difficult to strike a balance in those circumstances. For COC members also, it's very kind of unpleasant situation to question those valuers or the resolution professionals, and it creates a kind of unpleasant environment sometimes, which is avoidable if the valuers and the other professionals are chosen with care by RP, and only people with the highest standards of integrity are given the assignments, who have impeccable reports, track record of giving reasonable valuations. Of course, it is very subjective, but then yes, we can do to the extent whatever best we can. Then RP is also to keep himself constantly engaged with these professionals so that they deliver on time. We find many instances where transaction audit reports are not available even till the time of presentation of resolution plan, or even at the time of filing of resolution plan with the transaction auditor has not yet completed his job, because of which RP is also, in fact, regulations and code casts a responsibility on the insolvency professional to make a determination within the given timeline of 135th day, I believe, to finally file an application with the adjudicating authority for the avoidance transactions. But we have seen occasions when it was not possible for RP to do, or he could not do it, and COC had to go ahead with voting on the resolution plan without being aware of what are the avoidance transactions and what could be the implication of those avoidance transactions, leave alone recovering anything from those transactions. Even the quantum is not known. In some instances, I'm not saying always, many, of course, most of the time it is provided, but yes, there are real life instances when there were delays in conducting of the transaction audit and determination of the avoidance transactions. So it is expected that this has to be done timely. This should be done timely. And then RP has to also ensure that the information memorandum, which is a very important document for the PRA to frame an opinion with regard to submitting its expression of interest or otherwise, this information memorandum has to be very robust. It has to be a complete document which should provide complete information to the prospective RA without leaving any scope of doubt or any questions in the minds of the prospective resolution applicants, so that they are able to make up their mind. We have also come across instances where the RP could not or did not cooperate with the prospective resolution applicants to arrange for a visit of the unit of the corporate debtor, because of which the sometimes we receive as financial creditors, we receive complaints from some interested bidders that they are not getting adequate information, or they are not getting to visit the corporate debtor to assess the availability of the assets and assess their own valuation, etc. So we have to sometimes intervene. So it is the responsibility and expectation from RP that he will ensure that the cooperation is provided to all the potential buyers, bidders, and full information is made available. And he should also make efforts that maximum interest is garnered from the potential bidders. So it would require wider publicity. Apart from simply giving an advertisement in newspaper, it may also require some extra efforts on the part of resolution professional, on the part of his support agencies, and also definitely COC members can also contribute to that. That we try to maximize the value by creating interest in the potential bidders, by creating competition amongst the bidders. That is very important, and for it is very important that the information is spread on a wider upward basis, and more people are engaged in the entire process, so that we get a better interest of the potential bidders. Then convening the COC meetings regularly and keeping the COC apprised of the developments or whatever are happening. We came across instances where after forming the COC in the first meeting, RP did not convene a meeting for a long time. Of course, these instances are few and far between, but yes, still there have been such instances where COC was not kept apprised of what is happening, what sort of interest is being garnered, and which stage we are there. So it's a relationship of mutual trust, in fact, and that has to be maintained. One more challenge that, in fact, RP also faces and COC members also face is that the knowledge gap. See, the COC members are mostly, as you are aware, mostly institutions with thousands of people running the organization. If I talk of Punjab National Bank, we have 1,02,000 employees. And this IBC process is a kind of specialized job. Everybody cannot be expert because it requires a lot of reading, a lot of experience, a lot of grassroots level handling. And you are aware that as per the norms of the government and CBC, that people have to be rotated. There has to be job rotation every 3 years or whatever frequency is there as per the guidelines. So people are rotated from the jobs, and when new people are posted, they may not always be initially fully familiar with the subject, and it takes time for them to understand the subject, to get hold of the whole thing. And meanwhile, because of their ignorance, sometimes situations arise where the COC members, some of the COC members may not be fully equipped to participate in COC meetings or take decisions on spot. It all depends on individual instances. Some people would be who are already having experience. They would be there to take decisions. But yes, or job rotation, there will be new people coming in, and those kind of challenges would always arise. So, but RP, since he is handling multiple assignments, and by now it's already more than 5 years, and many of the RPs have already gained a lot of experience by handling several assignments. And for them, it is a repetitive assignment without any job rotation. So they are in a better position with better, they have a better knowledge to in fact even guide the COC members who may not be that equipped by virtue of their maybe new positioning in that role. So while going for expression of invitation for expression of interest, or while deciding the eligibility criteria for the PRAs, or while going for deciding RFRP terms, or maybe when we go for deciding an evaluation matrix to evaluate the resolution plans, all these things, it is the RP which is better equipped to equipped. In fact, COC has to approve these documents, but it is the RP which is better equipped than COC members even to guide them on these kind of documents, because he has already gained a lot of exposure and experience in what could be the weaknesses in terms and conditions of resolution those documents, which may create a difficulty later on. Anandji, up to what time I have to continue? I will wind up accordingly.
Sir, you can continue the way you want, because we have enough time with us. And please continue. We'd
Okay,
love to learn from you. And
okay, sure. So, we expect RPs to guide the COC members who are new to the process and may find it difficult to handle these kind of things. And then it comes with regard to the stage when the resolution plans are presented. At that stage also, it is the duty of RP and our expectation also from the RP that the plan will be thoroughly examined. Even the law casts this duty on the RP to see that all the plans are compliant with the code, with the regulations, with the RFRP document. Regulation 36A8 says that RP shall conduct due diligence based on material on record in order to satisfy that the prospective resolution applicant complies with the section 29A. Apart from inter alia, there are other things also, but this one particular aspect I want to touch upon, that section 29A. Now, one contentious issue that has often come up is that RP presents the resolution plan to the COC and obtains an affidavit from the potential RA, prospective RA, and that affidavit certifies that okay, I'm 29A compliant, and RP presents it as it is to COC. And in fact, I have heard the opinion of some of the RPs that it is for the COC to finally ascertain the 29A compliance, and RP has nothing to do in it. But I think RP cannot fully escape from the responsibility of making a prima facie due diligence of 29A compliance. Many RPs engage some professional agencies for this. There are agencies which for a fee carry out a 29A check and give their reports. Whether with the help of these agencies or without the help of these agencies, I think RP also is under an obligation, or at least we expect him to at least carry out due diligence based on whatever is information available to him, to make sure that only 29A compliant resolution plans are presented to COC. And if there is anything within his knowledge, then he should bring it to the notice of COC. I personally have an experience of attending a COC in the initial stage of those days, 2017, when a resolution plan was being discussed in the COC meeting. And when I joined that COC meeting at a late stage, and the plan was already under discussion, RP was just about to present the plans to COC. And I, by virtue of my some past experience, I knew that this particular resolution applicant in one of the group concerns has defaulted with my bank. And I brought out that to the knowledge of the entire COC and RP. Then RP, in fact, went back on, he held back the plan, and then he again went into detailed, carried out a thorough check and found that the TRA was not 29A compliant. So that was a coincidence that because I worked in one particular branch and I was aware of certain facts by virtue of just being there. Otherwise, it could have been escaped also. So, in the light of this, it is expected from RP that he will go thoroughly into this, because it is also mandatory as per law that the RA should be 29A compliant. After that, I would like to say certain things like when the distribution stage comes, plan is approved and the distribution stage comes, the resolution amount has to be distributed properly amongst the claimants. Claims have to be updated. All the because there are a lot of issues arise at this stage of distribution also. Some financial creditors holding superior security sometimes press for better share of the resolution amount, and it is for the COC to decide the distribution pattern amongst themselves. But nevertheless, RP plays a crucial role by providing complete information to the COC, because RP has gathered the entire information from all the financial creditors, and he's aware of the priority of charge and inter-se security pattern, based on which he can present full complete information to the COC members that this is the security structure, these are the claims, and based on which the COC can then decide the distribution pattern among themselves. Many times disputes arise amongst the COC members also on distribution. Proper admission of claims in the beginning is important. Disputes arise on admission of claims also. Of course, the things have settled down over a period of time. Initially, there were confusions about which claim to be admitted, contingent claims, and these kind of claims not. But the jurisprudence has settled over a period of time. Then a stage comes when the resolution plan is voted upon by COC and filed with the adjudicating authority, but that is awaiting approval from adjudicating authority, which takes many months, or even sometimes it is going in years. We have seen some resolution plans which have not been approved by the NCLT for last more than 2 years, and RP has to continue to run the CD during the intermittent period. And during that period, there is no COC meeting also usually doesn't happen. Once the plan is voted upon by COC, then COC doesn't much come into play actively. So that stage is also very, very crucial, when it is expected that RP will continue to manage the CD with the same interest and efficiency, and keep it as a going concern. And if CD is incurring losses, then it becomes further important how to handle that period when CD is incurring losses. And COC also having voted upon a plan and having crystallized the CRP costs may not be in a position to fund it further. And the resolution applicant also many times restricts the CRP cost to a particular amount which is already crystallized till the time of voting. And then it becomes a situation when nobody is ready to own up that particular period, and it is getting elongated because of the issues at NCLTs. This is a very challenging phase for the RP, and COC expects RP to balance that particular phase and handle it as well as he has handled the entire CRP process. Another expectation is when the company sometimes doesn't get a decent resolution plan and the COC votes for liquidation. And if the COC wants to change the RP at the liquidation stage, there we find many times, or not many times, but sometimes, that there is a resistance from RP in handing over the records or handing over the entire charge of the CD to the liquidator. Those kind of things could be avoided. If the COC wants to change an RP at a particular stage, probably that is the stage where RP should honorably quit that stage, because probably COC would have not found itself able to continue to trust that RP in terms of whatever. Maybe the COC wants to try something, some new person to think of a resolution, or whatever be the experience during that entire process. If COC has come to a conclusion that a new person should handle the process now onwards, it always helps if it is done with the grace, and then the relationship is maintained, and there is a possibility of future relationship continuing in another different case. The resistance basically spoils the relations for future as well. So the RP should present all the compliant resolution plans to COC. This is what I have narrated. We are at 418. So these are the expectations which COC can have from the RP. And now I would respond to certain issues which were discussed initially. One of the issues was that the COC always wants maximum recovery and the CD is on ventilator, and it may not be possible to bring. So there is no definition of maximum here. Second is it's very subjective to figure out what is the right time to bring a CD into insolvency process. Once the company goes into difficulty and the account becomes NPA, of course, over a period of time, we have learned that how to handle a situation with IBC as well. In the initial days, even the lenders or the COC members were not fully aware of how to handle it. All of us have been on a learning curve over the last 5 years and gained a lot of experience now. The biggest challenge in this entire thing is the admission is getting delayed. So even if we decide to initiate the insolvency process immediately after the account becomes NPA, and many times we do that, but the admission, I have a particular particular case which got admitted after almost 3.5 years after first application. So these kind, and I don't want to quote the names, but I have numerous instances which are waiting admission for more than a year. The number is very high. 1 year has become a kind of a very bare minimum time. And it would be surprising, I don't know whether to comment that or not, that the operational creditors applications are quickly admitted, but the financial creditors applications take many times several months or years. So if an application is filed today, it gets admitted after 3 years. So of course, the challenge lies for COC as well as RP, because in the meantime, when the promoter knows that the financial creditor has already gone into insolvency process and application is filed, which may be admitted anytime, he would try to siphon off whatever maximum is possible in the interim period. He knows that one day the application is going to be admitted. He may create hurdles for a limited period of time. In those situations, he may speed up the process of taking out money from the CD and finally leave CD in a junk state when it finally gets admitted. So it becomes very challenging for RP also to bring a good value. And COC also has to then finally settle down with whatever is available. So that challenge is kind of for both sides. So we are together into this. Then another issue was raised was the L1 system of selection of RP leading to very low fees being quoted by them. So at least on behalf of PNB, I can say with confidence that we don't have L1 system. We have a evaluation matrix for selection of resolution professionals, and 80% weightage we give to the technical and efficiency and past experience technical parameters, and only 20% weightage we give to the fee part. In fact, till last year, we used to give 70-30, and this financial year, when we went for review of our internal policy, we increased the weightage for technical parameters and brought down the weightage for the financial parameters. So thereby, any assignment that is given to any RP, it is evaluated on internal evaluation metrics duly approved by the board. 80% weightage is given to the past success ratio, past experience, and several other parameters. We have a elaborate evaluation matrix. Finally, we give to the person who scores the highest marks. And the scope of subjectivity in this entire process is minimal. Many times we are even not able to give an assignment to a person which we may like to give, just because he is not scoring highest marks on the matrix. So in our bank, to the extent possible, and I have brought out these changes post amalgamation when I started heading these NCLT cell in PNB. So these kind of things I got approved from our board, and these are in place now. So we try our best to ensure quality is brought into this. As far as not paying fees to the RP, this issue was raised. I don't know. There could be instances, but as far as PNB is concerned, over my 2 years of experience, I can't. I don't have a single instance where we have refused to pay the agreed fee to any RP, because fee is already agreed in advance. So there is no point in not paying the fee which is already agreed. But nevertheless, I can't comment on behalf of the entire banking system. There could be individual instances of differences of opinion leading to holding back the fee. I won't be able to comment on such instances. Next was the backdoor negotiations for settlement with the promoter. This issue was raised. So I would like to say that many times it happens when the CRP process is initiated and the case gets admitted, the promoter comes running to the financial creditors that, okay, I'm willing to settle this. And it's nothing new or nothing surprising. And if the promoter wants to retain control of the company, and he has been non-cooperative earlier, so at least the IBC thankfully has done a good job that it has created a fear in the minds of promoters. So promoters come forward for negotiation and settlement, and I don't think there is any role for the RP to come into the negotiations for settlement. Settlement is not a part of the resolution process. Settlement is outside IBC. Even Section 12A means you are quitting, you are exiting the IBC process and then settling with the promoter. Even before triggering the IBC process or NCLT process, the banks can settle with the borrower, and they are settling, and they are well within their right. So if the insolvency process is triggered, at that stage, if the promoter wants to come and negotiate with the financial creditors outside IBC to settle the account, and then financial creditors with 90% voting power decide to withdraw it under 12A, so that is well within the legal framework, well within the rights of the financial creditors, and I don't think there is any role for RP in this negotiation. With regard to IBBI circular of August 2018 for attending the COC meeting only by the people who are competent to decide on the spot, I already said that COC members are institutions of public trust. We run on depositors' money. So there have to be checks and balances. There have to be delegation of powers as per a laid down system duly approved by the board of each institution. Powers cannot be delegated for important. I mean, powers will be delegated according to the importance of the issue. At PNB, we have delegated powers to the field functionaries who attend the COC meetings for all the routine issues, except for resolution plan, and except for cost beyond a threshold. Certain amount power, and which is very liberal, in fact, we have given to the field functionaries. Very rare instances come to head office for approval of expenses. Those are also approved within 1 or 2 days. As far as resolution plan is concerned, definitely the powers are not delegated to the field level. Those powers are restricted to committees at various levels. Field level committees are also given power, but those powers are limited to a small amount. Larger haircuts, and you can understand that a lot of hue and cry is made when there is a large haircut, and looking at 80 to 90% of haircuts these days is not a surprise. So these kind of large haircuts can be taken only by the senior level committees. And that becomes a very, very big challenge for COC members to handle those situations. Such kind of critical decisions cannot be taken on spot, and adequate time is required to analyze those decisions, weigh the pros and cons, and take it to the appropriate committee, convince the committee members, get an approval, and this may require time sometimes. Of course, for taking routine decisions, day-to-day decisions, appointment of valuer, appointment of another professional, for for fixation of remuneration, for RFRP document, and all these things are powers are delegated to the field functionaries. Of course, there could be gaps in knowledge. I already admitted that people keep on moving because of job rotation. there could be gaps in knowledge, but we always make efforts as an institution to equip our people. I have been holding internal webinars to educate my people in the field. I have visited my internal training center to hold sessions on IBC process for our internal staff members. Those efforts, we also prepare some internal material, some kind of booklet for the knowledge and enhancement of the field functionaries. We hold a kind of meetings. We also circulate video lectures. So these kind of efforts are made from time to time to educate the people who actually participate in COC meetings, and it is a continuous process, and it would differ from organization to organization. It cannot be generalized. Some people would always be better equipped than others. With regard to the analogy given by the other esteemed speaker, husband-wife relationship, and in this relationship, he said that RP is a husband and the COC is wife. I'll agree to this analogy to the extent that yes, it is a relationship of mutual trust and mutual respect. To that extent, I would agree with that. Who is husband, who is wife, is a matter which is debatable. I won't go into that. COCs, with regard to the code of conduct for COC, a lot of discussion is already happening at various forums. So if there is a code of conduct, of course, there should be a code of conduct for each stakeholder in any process. But only thing we need to know that we need to keep in mind is that COCs are not individuals. COCs are institutions. Only individuals have limited power given to them, delegated to them by their respective institutions to represent the institutions. If I take a decision today, it's not my decision. It is the decision of Punjab National Bank, and I will derive authority from my bank. In my personal capacity, I may have no authority at all. So COCs are institutions which are already regulated by Reserve Bank of India, already regulated. There are checks and balances. There is a vigilance department. There is a CVC. The decisions are questioned by various agencies. They are already subject to tough regulation. Each of the decision, as already said, that each of the resolution plan is approved by a committee which comprises of almost not less than 10 people in each organization. Those 10 people are from different departments, risk management, and several others. So they together jointly, 10 people, 15 people coming together and taking a decision is already checks and balances are in place. So with that, if there is anything left out, no issue. We welcome any code of conduct. If there is any gaps in the entire process, those should be plugged. So we are at 4:30, and that is from my side. If there are any questions, I'll be happy to answer. Thank you very much for listening patiently.
Sir, thank you very much. You enlightened us, so gracefully and so meticulously that we were really obliged. As an IP, we are really obliged. You are talking with your heart. और जब आप कोई आदमी दिल से बात करते हैं ना तो वही बात निकलती है जो प्रैक्टिकली दिक्कत आ रही है. Personally, I'm really obliged the way you tell us your expectation from VIPs. सर, I fully endorse your view. आप जो बात कर रहे हैं बिल्कुल ठीक बात है. और ये जो पॉइंट्स आपने कहे ये ऑलरेडी लॉ के अंदर प्रोवाइड है, रेगुलेशन के अंदर प्रोवाइड है. बट स्टिल सर, देयर इज अ बिग गैप. अब जैसे हमने 92 की बात करी, 92 की एप्लीकेशन जितनी मर्जी डाल दो, कहीं पे कोई रिपल्सिव एक्शन कोर्ट की तरफ से नहीं मिलता. ये सर हम लोगों ने चलो 10, 15, 20 असाइनमेंट्स हैंडल करी होंगी. आप तो यू आर हाईली एक्सपीरियंस और पायनर इन दिस एनसीएलटी वर्क. तो ये एक व्हाट अब जैसे आपने सर बात करी, जैसे मैंने एक थोड़ी सी इशू छेड़ा कि वैल्यूएशन हमारे पास तब आता है कि सीडी को तब आईबीसी में आता है जब वो वेंटिलेटर पे होता है. तो सर आई मीन टू से दैट कि इवन जब अगर हम लोगों ने जब आईबीसी स्टार्ट हुआ तो आईबीसी का ऑब्जेक्टिव क्या था? टाइम लाइन वाज वन ऑफ द बेंचमार्क इन आईबीसी. लेकिन अब कोर्ट की तरफ से इतना टाइमलाइन डिले हो जाता है, जैसा आप भी कह रहे हैं 1 साल. मेरी कई आईआरपी की अपॉइंटमेंट्स के लिए 2.5, 3 साल हो जाते हैं. सेक्शन 10 की एप्लीकेशन हो कुछ हो तो मीनिंग देयर बाय इज दैट कि बहुत सारी चीजें हैं जिस करके हमारा आईबीसी इतना इफेक्टिवली नहीं आ पाया जितना इफेक्टिवली हम लोगों ने सोचा था या एक गवर्नमेंट ने सोचा था इनिशियली। और शायद उसका सबसे बड़ा रीजन यही है कि डिले इन डिसीजन मेकिंग विद ड्यू रिस्पेक्ट टू आवर ऑनरेबल कोर्ट्स, शायद उस करके थोड़ा सा मिसमैचिंग हो रहा है, जिस करके यू नो वी आर नॉट perhaps able to satisfy to COC, or COC is not get satisfied to that extent, to the extent to which they were there. अब सर एक आपने इशू रेज करा 80% टेक्निकल 20% फाइनेंशियल, सेम यू नो सिचुएशन इज विद मोस्ट ऑफ द बैंक। इवन स्टेट बैंक ने स्टार्ट करा था तो उसके बाद अभी बैंक इज फॉलोइंग इट। बट सर उसके बावजूद अगर आप देखिए, अगर प्रैग्मेटिक व्यू से इसको चीज को देखें आप, तो ये इवैल्यूएशन पैरामीटर पक्का है। आपने भी इस बात को एडमिट करा कि हम कई बार चाहते हैं कि हमारे पास ये बंदा आया, वो नहीं आ पाता। बट डिस्पाइट दीज टू पैरामीटर्स, जितने भी आप जनरली 5 लोग सिलेक्ट करते हैं जो टॉप के होते हैं, उनमें से फिर एक बंदा एज एन आईआरपी सिलेक्ट किया जाता है। तो उन 5 के टेक्निकल्स तो जनरली मार्क्स इक्वल होते हैं या अप्रोक्सीमेटली इक्वल होते हैं। अब फाइनेंशियल के अंदर यू नो देयर इज अ बिग गैप इन डिमांड एंड सप्लाई। जैसे मैंने शुरू में कहा कि हमारे यहाँ पे इस समय 4000 के आसपास आईपीज है। 4000 के आईपीज में से ओनली 500 या 600 आईपीज है जिनको एक्सपीरियंस है और जो काम कर रहे हैं। और बाकी जो बंदे हैं 3000 या 3500 आईपीज, उनके पास बिकॉज ऑफ एनी रीजन, चाहे कोरोना हो या कोई और रीजन हो, शायद उनको एक असाइनमेंट भी नहीं मिली। अब जब आप इवैल्यूएशन के अंदर, टेक्निकल के अंदर, नो डाउट दे वोंट बी एबल टू कम फॉरवर्ड, तो एक जो फीस स्ट्रक्चर है जो वो है, वो एक थोड़ा सा प्रॉपर बैलेंस बन नहीं पाता। और अमंग V600 आईपीज आल्सो इनिशियली बहुत सारे, आई रिमेंबर सर व्हेन यू वर आईबीसी ओबीसी, तो ओबीसी के अंदर शुरू में 2017 में 18 में बहुत सारे केसेस निकल रहे थे। अब बिकॉज ऑफ एनी रीजन, यानी कि मे बी जो आउटकम है या जो आउटकम एक्सपेक्टेड थी वो आईबीसी से बैंकर्स को नहीं मिली। दिस इज अ फैक्ट कि वो रिकवरी जब वो नहीं मिली, as a result of which you know bank may be not much inclined for going to the IBC more, but that is also a pitfall. So इसी में you know, but I showed you on behalf of the whole community, आपने जो पॉइंट्स लिखे हैं सारे के सारे पॉइंट्स मैंने नोट डाउन कर लिए हैं, और इन पॉइंट्स को हम अपनी कम्युनिटी के अंदर वी शैल ट्राई टू शेयर विद देम एंड ट्राई टू कम आउट विद द एक्सपेक्टेशन। एंड आपकी सारी एक्सपेक्टेशन जो है दीज आर एब्सोल्युटली जेन्युइन, एंड ये आप ही की एक्सपेक्टेशन, ये लॉ की एक्सपेक्टेशन भी है। लॉ आल्सो यू नो एक्सपेक्ट फ्रॉम अस कि हम टाइमली सीओसी की मीटिंग ऑर्गेनाइज करें। हम आपने एक यानी कि कंप्लेन करी, कंप्लेन कि आपकी एक एक्सपीरियंस था कि वेयर बाय यू सेड कि प्लान आता है एट द फैग ऑफ एंड ऑफ 330 डेज। बिल्कुल ठीक बात है। जो ट्रांजैक्शन ऑडिट कर लो या फॉरेंसिक ऑडिट की रिपोर्ट ही नहीं आ पाती तब तक, तो दीज आर ऑल फॉल्ट, आवर फॉल्ट, ये हमारी गलतियां हैं। वी शुड प्लान इट। अगर 135 डेज के अंदर हम उनको पॉइंट करके कर लें तो क्यों ना करें, तो क्यों ना टाइमली हो, या हम क्यों ना अगर किसी कंसल्टेंट से किसी भी कारण से डिले हो रहा था, वी आर बाउंड टू फाइल, सॉरी वी आर बाउंड टू फॉलो इट अप सो दैट टाइमली हर चीज हो, बिकॉज टाइम इज मनी। और आईबीसी में तो है ही टाइम एवरीथिंग। वैल्यूएशन के मैक्सिमाइजेशन के बाद सेकंड एक्सप्रेस जो है टाइम लेना है। बट सर यू नो यू आल्सो एडमिटेड, वी आल्सो एडमिट, लॉट ऑफ डिलेज आर फ्रॉम द एडजुडिकेटिंग अथॉरिटी। अगर ये डिले थोड़ा सा कम हो जाता तो शायद आईबीसी जो एक ये कोड है, ये कोड जिस ऑब्जेक्टिव से बनाया गया था उस ऑब्जेक्टिव के हिसाब से ये बहुत ही अच्छा एक रिकवरी दे पाता ये फाइनेंशियल क्रेडिटर्स को भी, और हम इंसॉल्वेंसी प्रोफेशनल्स को भी एक बहुत अच्छी हमारी लाइफ के अंदर एक अपॉर्चुनिटी देता अपने आप को क्या कहते हैं आगे बढ़ने के लिए। थैंक यू वेरी मच सर। अब एक दो क्वेश्चंस हैं जो इससे रिलेटेड ही हैं। सर पहला मेरा आपके, सिंस यू आर हाईली एक्सपीरियंस, वी हैव सीन थ्री थिंग्स। वन इज आईबीसी के अंदर ये सिचुएशन जो है क्रेडिटर इन कंट्रोल है। पहले डेटर इन कंट्रोल होती थी, हाँ प्री पैक के अंदर अभी भी डेटर इन कंट्रोल इन्होंने करा है, और एक सरफासी है। Considering your experience and your totality of circumstances, what do you see the future of going forward under any of these three laws?
See, these three things are three different things. These are the three different tools, and I would not say there is any overlapping in these tools. As far as SARFAESI is concerned, SARFAESI is only to dispose of a security through the auction process without the intervention of the entire code process and defined process. So SARFAESI is successful only when you have to dispose of a particular immovable property. It may not be very helpful when there is a large manufacturing unit which is operational and there is a delinquency and the promoter is not cooperating. You can't do anything under SARFAESI. Then IBC is the best route for a larger asset. SARFAESI is helpful for maybe 5 crore, 10 crore kind of a security realization. But when it comes to hundreds of crores, SARFAESI is not effective. So IBC has proved to be much more effective. And we should not forget the initial success stories that we have seen in IBC. Initial 2-3 years, it really did us marvelous results. Of course, in the last 2 years, things have kindly deteriorated, to some extent deteriorated. It could be COVID impact, it could be other things, whatever. But yes, initial 2-3 years, we were very, very hopeful and very exuberant about the IBC process, and we have seen good successes coming. So still, I believe that if there is a large asset which has defaulted and promoter is not willing to cooperate and come to the lenders for restructuring or any other amicable solution, then definitely IBC is the way forward. As far as pre-pack is concerned, pre-pack is also, for the timing, it is only aimed at MSME units. In MSME units, it's mostly one lender or two lenders. And the promoter has also, the size of the debt is a decent kind of 25-50 crore of kind of a debt. And if there is a single lender or maximum two lenders, and the promoter is also more willing to hear the lenders and cooperate, then they can sit together and resolve it, even outside the formal framework. RBI framework for restructuring is there. In the last 2 years, in fact, RBI came out with the COVID-affected restructuring also, restructuring for COVID-affected units. So, if both sides are willing to consider each other's difficulties, then there is no need to trigger the formal IBC or pre-pack process. Only where there is a resistance, then you have to forcefully go for these kind of steps. So everything will prevail, continue to prevail. Of course, pre-pack is yet to pick up. Going forward, let us see how it pans out. But SARFAESI versus IBC is not a debatable issue. Both have to coexist.
Okay. Thank you very much. Okay. It means that as an insolvency professionals, maybe there was a lull because of any corona or something like that. 2 years was the period, and there was a lot of delay in the admission of cases at NCLT also. IBC has a bright future, and as far as the resolution or recovery or whatever we call it, a lot of cases is going to come in the coming months or days, and that will really help us out. Sir, दो चीजें मैं एक anybody has any question to ask, please? I ask from the audience if any audiences have any question to ask. No. At least there are 2 or 3 questions which they're asking for YouTube link or CPRs or something like that, but nothing technical. Sir, 2 developments पिछले 2-3 दिन के अंदर हुई हैं, which I would like to share with you also and with my fellow friends also. Although I have made presentation for that, but since it's already 441. एक तो sir development ये हुई है कि against our demand, IBB has come out on 9th of June with a discussion paper and with a notification also, whereby they have settled the fees for the insolvency professional. But just hold on, if I have got presentation, I can move there.
I think you can even otherwise finish up in 2-3 minutes.
Okay.
Yes, it's a welcome move. It's a contentious issue. There has been a lot of talk about the fee of the RPs, and there is undercutting and very low fee being quoted. Even we feel uncomfortable with very low fee being quoted by RPs, then we are not very sure of the quality work. So it's good if regulator comes out with some indicative guidelines for the fee also, that would settle this issue. and
Yeah,
that is a
this is
welcome move.
yeah, this is what I was saying कि जो लोकधीर सर ने थोड़ी सी बात कही थी, तो वो उसका सोल्यूशन आरपी ये ऑलरेडी प्रोवाइड कर दिया गया है। नंबर 1, नंबर 2 इशू ये आ रहा है कि जो नाउ लाइक जैसे आज की डेट में हम आईपी एज एन इंडिविजुअल ही एलिजिबल थे फॉर डूइंग आरपी आईआरपी वर्क एंड ऑल दिस वर्क, परहैप्स देयर इज अ बर्ज इन द वर्ड दैट आईपीई जो इंसॉल्वेंसी प्रोफेशनल एजेंसीज हैं, सॉरी इंसॉल्वेंसी प्रोफेशनल एंटिटीज हैं, इनको भी अलाउ करा जाएगा फॉर डूइंग वर्क, जैसे कि हम लोग बैंक के अंदर एज ए सीए फॉर्म में ऑडिट करते हैं, इधर इन द फॉर्म ऑफ एलएलपी और इन द फॉर्म ऑफ पार्टनरशिप फॉर्म और समथिंग लाइक दैट। तो आईपीई की भी रिकॉग्निशन आने वाले टाइम में शायद आईबीए परमिट कर देगा। तो दीज आर दी टू वेरी मेजर डेवलपमेंट जो शायद हम लोगों ने आपस में डिस्कस करी थी कि जो एक थोड़ा सा गैप है उसको फुलफिल करेगी आने वाले टाइम के अंदर। जब इंडिकेटिव फीस आपके लिए आ गई थी, इसको उन्होंने 2 पार्ट में डिवाइड करा है। आई डोंट डेल्व इनटू डिटेल। एक पार्ट है जो कि मैंडेटरी है और दूसरा पार्ट है कि जो सीओसी के डिस्क्रिप्शन पे है। तो शायद अगर मैंडेटरी पार्ट के अंदर उन्होंने 1.5 लाख रुपए से लेके 5 लाख तक का फीस का कुछ 10 लाख तक फीस का रखा है, और डिस्क्रिप्शनरी पार्ट के अंदर अगर आप जल्दी करते हो तो देन यू विल बी एबल टू पे दिस मच फीस, और यानी अगर आप रजिस्ट्रेशन जल्दी ला देते हो, अगर आपका दूसरा ये है कि रिकवरी अगर आपकी अच्छी है तो देन यू विल गेट दैट मच फीस। तो दैट इज अ वेरी गुड मूव फ्रॉम द दिस इंडिया। और तीसरी जो बात है, जो इंटरम फाइनेंस की बात, जो दिक्कत जो आ रही थी, जो अदरवाइज आ रही थी, उसके अंदर भी दे हैव ब्रॉट सम S2 sort of the S2 type of account and all this thing that will also be work. What I mean to say is that कि with the passage of time जो हल्के फुल्के से हमारे बीच में थोड़े से differences हैं वो कम होंगे। And with this note of I would like to end my webinar. Sir, anything else from your side?
Only I would say that I invite you and the other participants as well, if you have any suggestions, because it's a continuous evolution process. We went for 70-30 to 80-20 ratio, and still we think it may further require. So if you have anything in your mind that which can make our system procedures better, you can reach out to me, and I would be happy to look into that. And if we can improve upon further in our internal policies, that would be my pleasure. Thank you very much for inviting me for this deliberation. I'm honored. Thank you.
Thank you very much, sir. We shall definitely come from the association perspective with you. ये हमारा इसके अंदर था. With this note and with vote of thanks to you for sparing so much time and enlightening us with your good knowledge. Thank you very much, sir. Thanks for coming. Thank you very much.
Thank you.
I'm ending meeting for everybody now.
Yes,
Thank you.
yes, please.